Thank you, Mr. Chairman, and thanks to all of you for your help and for your insight today. I'd like to thank all of the other original co-sponsors, Senators Leahy, Cornyn, Schumer, Hatch, and Klobuchar, for their work in putting together this really important legislation. In the last Congress, Senator Leahy and I proposed legislation to deal with abusive patent practices directed at small businesses, sending demand letters, extorting money, and filing expensive patent infringement lawsuits filed against retailers and other end users of products that instead of against the manufacturers of those products. We're pleased to report that in the Patent Act, with the support of a bipartisan array of co-sponsors, we'll finally be able to enact these reforms. And so it's been a pleasure working with this great bipartisan group and with so many people in the industry who have provided such valuable insight. I'd like to start with you, Ms. Letelier. You said in your testimony that you support a statutory customer stay. Just want to make sure that everyone understands why that's important. So JCPenney is in the retail sales business. Now, you all don't manufacture technology or design complex software for a living, right? You sell clothing and you sell other merchandise. You don't know anything about the microprocessors in the barcode reader or some other technology that you use in order to get on with your business. And so when you get slapped with a patent infringement lawsuit over some product that you didn't design, that you didn't manufacture, you're not going to be able to evaluate the merits of that suit. The manufacturer has to do that. Yet, according to your testimony, district courts are currently somewhat reluctant to stay litigation against retailers or against end users, even where their manufacturer is already defending its patent litigation. Can you tell us a little bit more about that and about how you think the customer stay language in this bill will help in the industry?
Yes, thank you for your question, Mr. Senator Lee. We have been called upon to defend various aspects of technology we have acquired from other companies like Cisco, companies like Oracle, Intel processors. It's the whole array of technology that you can imagine we've been called upon to try and to defend. And you can imagine when JCPenney is sued on the premise that an Intel chip that resides in its point-of-sale terminal in its store, that we are at a severe disadvantage in terms of even beginning to defend that technology. We do not have access to the evidence that would even be required to defend that. So a customer stay is very important to us with respect to those particular types of suits. It's not all the suits that we see, but it is a good percentage of them. And it is, I think the customer stay provision is really geared towards getting to the truth. Does the chip infringe? And it addresses the issue of who is the best party to defend that issue. And we feel it's the manufacturer, and we think that the language that has been carefully crafted to balance all the different interests of the different stakeholders is the best way to get to that result. It doesn't absolve us of liability, but it does shift the burden of proving and addressing the infringement allegations to the manufacturer who actually supplied the technology.
Thank you. Now, Mr. Rhodes, you've been focused, and appropriately so, on ensuring balance in our litigation reform proposals. You've been an honest broker in this process, and I hope you know how much we appreciate that. Are you satisfied that under our proposal, eligibility for a customer stay is sufficiently far down the chain of distribution?
Yes, thank you for the question, Senator Lee. I do think that we took careful pains, as I mentioned earlier, in the definition of who a covered customer is to limit it to retailers and end users who are reselling products from covered customers who are in a position to defend the case. They have not manufactured. They have not modified the product in a way that gives rise to the charge of infringement. They are well positioned, if they have done that, to defend based on their modifications. So I think with those protections in place, we're not talking about absolving people of liability. I think that's an important principle on which I agree, but we're talking about, in the first instance at least, having the parties well positioned to defend the case have the first and foremost role in defending it.
Okay. Thank you very much. I see my time's expired. Thank you, Mr. Chairman.
Thank you. Now, Senator Durbin.